Security consultant Richard Kumado has sharply criticized the legal team of former Finance Minister Ken Ofori-Atta, describing their handling of his case as a serious misstep with significant national and international consequences. Speaking on the Midday News earlier with Beatrice Edu here on 392.7 FM, Kumado highlighted the far-reaching implications of being declared a wanted person or fugitive, an outcome he believes could have been avoided if Mr. Ofori-Atta and his lawyers had engaged more strategically with the Office of the Special Prosecutor.
Definitely, yes. And the risk goes beyond the individual. Sometimes when we do the profiling to the third level or to the fifth level, it affects your immediate bloodline, it affects your associations, it affects your businesses, and it affects your acquaintances. Then when it comes to some transactions and activities you might want to engage in certain parts of the world, issues of fraud, financial crime, and money laundering and crime-related red flags will always pop up. And you and all the people that have been affected will have some questions to answer. This is the reason. The INTERPOL platform is a very huge platform with a lot of followers. And all investigative agencies and prosecutorial institutions, departments, and units are all going to have access to your profile, and they will expand the spread to other databases that goes way beyond the INTERPOL platform. Financial institutions, service providers, border control, and many other institutions get involved, and those are the levels of red flags you are going to be dealing with, and that is why it's not a funny thing when you are declared wanted or fugitive.
It's not a funny thing you say, and people are saying that perhaps the lawyers of Mr. Ofori-Atta could have done better knowing the implications. Would you share that same view with them?
Definitely what I said to one of them to tell them. Definitely. Because these are not things you take lightly. It's not just the immediate person. And because when we do the profiling or law enforcement agencies do the profiling, these are things that are going to stay in the database for life. And people with your surname are going to be affected whether they are directly related to you or not. So I was thinking they would have made halfway, considering the fact that there's bad blood and there's confrontation and agitation between the OSP's office and the lawyer. They could have made halfway rather than allowing him to be declared fugitive and a wanted person. It goes way beyond what we are thinking. It's not just when you kill somebody. We are talking about businesses and personalities and families and associates, and your name pops up all over the world when it comes to all databases, and you'll be hiding in your room or wherever you go, you are fugitive. Because I can tell you.
Richard Kumado is a security consultant. We can now listen to Dr. Victor Doke, security expert at the Kofi Annan International Peacekeeping Training Center, who said the order means any Ghanaian living everywhere can now cause the arrest of the OSP.
With regards to this particular issue, if assuming everything goes well and then even the country where he is, the authorities effect the arrest and then he decides to go, and then also try to sort of like rebut or whatever, and we are looking at how the country is also going to respond. We are looking at bilateral relations with that country in particular also, and if they are able to effect this process to the latter, how would they also want Ghana to respond in any case in future if it happens that there's a fugitive here who has to be extradited from Ghana here. So it's a give and take issue.
Victor Doke there talking to us about how now everyone anywhere in the country, because of that red notice anywhere around the world, can cause the arrest of the former finance minister Ken Ofori-Atta. Let's have a quick chat on the back of this. In the meantime, if you went to Facebook right now, you see that Interpol alert for the former finance minister Kenneth Nanayaw Ofori-Atta is there with his particulars, as they put identity particulars, his family name, his full name, his gender, his date of birth, place of birth, nationality, distinguishing marks, which he has none, and so on and so forth. But let's have a quick chat now. Christian Malm Hesse is a legal practitioner who's maintained that a court of competence jurisdiction is the preferred forum to determine whether Ken can be listed on Interpol's website. We'll bring him on into the program right now. Christian, good afternoon to you. Let's talk quickly about the situation. This is the best move the OSP could have made at this point, isn't it?
Yeah, good evening and thanks for having me. Yes, I mean, it is one of probably two options the OSP could have done. I mean, that just as you have expounded on it, it is one that we all know that Mr. Ken, at that material time, was invited over, even though he was out of the country, for him to cooperate with the OSP in respect of certain allegations relating to corruption and corrupt-related matters. However, it seems to suggest that he has not been able to be present. The OSP maintains that even though there remain insinuations of ill health, he has not formally informed the OSP of the particular medical issues surrounding his person. However, the OSP has maintained its grounds to progress with the matter, and it has resulted in putting him on Interpol wanted list. It must also be said that while the OSP has all the due process to do that, it follows through with the Interpol and then would then move into extradition. It is no mean feat because the procedures involved to procure the order, basically, assuming without admitting that Mr. Ofori-Atta is in the country and is failing to cooperate with police asking for arrest, normally the police would go to the district or the circuit court to procure an arrest warrant. And then after getting that, the particulars of that particular person, as we have it, will be published on their circulars around as a wanted person. And in the situation where the person is out of the country, you would have to channel the details of the arrest through Interpol because Ghana is a member state. So this is what we have seen.
Indeed, Christian,
happening.
We also hear the likes of Richard Kumado say that the legal team of Ken Ofori-Atta have not done him good, and essentially they brought this upon themselves. What would you say to that?
It will be unfair for me to slight my colleagues down. I will not shudder to say or to affirm what he said, but I mean it is for everybody to judge. It could be presumed that the lawyers have their strategy they are playing, but what it is that as the matter moves into extradition, it would be for the transferring state to confirm the legalities involved, to the legal charges. As it is now, he's merely a suspect, he's not an accused, and so where the extradition processes have been kicked in by UK or US, it would be for Mr. Ken Ofori-Atta to challenge the process in these two countries, and that is where the legal process could become, as we call it, complex, because it is not simple to say that once you have put a person on Interpol, the transferring state would immediately surrender the person. No, it doesn't happen that way. Those countries would also consider the rights of the person, especially when that particular person is challenging his extradition. A court of competent jurisdiction would have to hear him, and that is where the OSP is going to face the challenges. I mean, everybody must be listened to because that's natural justice.
I see, Christian, just a couple of things and then we move on from this, right? There are those who have criticized the OSP's, the way the case is being handled. I guess my question to you would be whether or not, based on the documents we have seen asking the OSP to postpone that meeting between the special prosecutor and Ken Ofori-Atta, or do it remotely, whether those documents are enough to have prevented the OSP from putting him back on the red notice list.
Yeah, I mean, OSP's legal point is that, I mean, when you look at the criminal jurisprudence of the country, when an arrest is made, it is for you to be present before the arresting officer or the CID, so that your details will be taken. It is not done remotely, and while it's not done remotely, your caution statements and everything will be taken. And so an invitation is not in the literal sense of an invitation where you could have a virtual call with the OSP, because it is not one of pampering. It is one of criminal investigation. So your presence is much needed, and by that, his presence as needed. He has not availed himself. OSP is of the belief that no credible position has been advanced by him, and that is why OSP has commenced in that direction. However, if that Mr. Ofori-Atta has not cooperated, OSP could proceed with criminal proceedings in absentia, and it is not alien to our criminal jurisprudence. And we have situation. If you look at Article 19, it deals with the fact that while a person is arrested, that person should be given fair trial, and the trial should happen in the person's presence. Now, however, there's an exception where the person fails to allow for the continuation of such criminal proceedings. Then the proceedings will happen in the person's absentia. Absentia means it's a Latin for in the absence of the person. So that is also another option. That's why my preliminary statement.
An option you'd expect the OSP to take up immediately.
Yes, he has one of the two options too, and that would mean that. But the court always maintains that before the trial by absentia happens, there must be a legal justification that would inure to that process happening. And if OFC believes all that he has said to us is anything to stand in or to stand by in law, then those justifications will be given in the court of competent jurisdiction, and where the court is convinced, will allow the process to happen in absentia, basically to guide and protect the fundamental human rights of Mr. Ofori-Atta. And the court would also ensure that at all points in time, notices of the progression of proceedings will be served on him, so that if he decides to waive his rights, then that's it. We should also not forget that under the Constitution and also our criminal procedures, where one is even arrested, say that Mr. Ofori-Atta is arrested today, he has the right not to even write a statement. So where the OSP is inviting him to do caution, to have his caution statement and everything, the law says that he may decide to write a statement. He may decide not to. So if we are to assume that Mr. Ofori-Atta is present and he has refused to put a pen on paper to write his signature, to write his statement, what is the OSP going to do if he fails to? So there are options the OSP could assess.
See, sounds like a much more complex situation than would like to believe. Thank you so much, Christian, for talking to us. Christian Malm Hesse is a private legal practitioner. We'll stay on the subject of graft because the special prosecutor, Kennedy Agyapong, has advocated for a more robust asset declaration mechanism that would include verification and tracing of undeclared assets. Delivering a keynote address at the high-level conference spearheaded by the African Union Advisory Board Against Anti-Corruption in Accra, Kennedy Agyapong said the legal regime must evolve to meet the sophistication of modern corruption schemes.
there should be a more robust and effective asset declaration mechanism in respect of public officers and persons undergoing lifestyle audit to close the loop on the amassing of illicit wealth and to enhance accountability. We should move beyond mere repositories to a system of verification and tracing undeclared assets. However, I do not, and I will not add my voice to calls for the publication of assets for public scrutiny. In our experience, it will be unhelpful and would merely subject public officers to inordinate public curiosity and the specter of the real likelihood of reprisals against their assets. In my estimation, a publication of who has declared or has not declared his assets in the context of a workable asset verification and tracing model would be sufficient to assure the integrity of the asset declaration system. On another score, I dare say corruption begins where values collapse. That is why integrity must be designed into our educational system, from the basic level through to the tertiary level. And I'm looking at students. A student who regards a corrupt businessman as his or her role model would invariably emulate him without remorse. Do not do so. A society in which the youth adore and celebrate ill wealth would only reap get rich, corrupt, and fraudulent practices. I cannot state all that is on my mind on our accountability journey at this stage, Your Excellency, except to say that we must strive to change the narrative and fashion our own course and course by keeping the glimmer on the horizon glowing until the light beckons closer and shines overhead in a just and prosperous trajectory.
Kwesi Agyapong is special prosecutor of this republic. Now, Vice President Professor Nana Jane Opoku-Agyeman, the same event, called for bold and systemic reforms to strengthen the country's anti-corruption architecture, emphasizing the need for constitutional amendments. The Vice President was speaking at the same high-level conference on Ghana's corruption architecture here in Accra.
Revitalizing Ghana's anti-corruption architecture requires bold actions across multiple fronts. We must legislate and revitalize unexplained world orders, extending the application to both public officials and private citizens, while anchoring the principle of reverse burden of proof in our Constitution. The revised conduct of public officers bill will onboard the views of CSOs, anti-corruption institutions, the media, academia, the international community, and all relevant stakeholders to ensure that this bill stands the test of time. The bill will be open to a comprehensive engagement by all stakeholders, and its content and passage will once again demonstrate our commitment to accountability and the fight against corruption. Definitely, you talked about the asset declaration, and I agree with the major points you have made. We must ensure also that we have sustainable financing for anti-corruption institutions to reduce their influence and also to enhance their independence. The financing of political parties and national elections must be regulated through comprehensive legislation that addresses both internal party leadership selection and national campaign funding.
Vice President Professor Nana Jane Opoku-Agyeman, let's have a chat on the back of this. Adam Senanu is co-chair of Citizens Movement Against Corruption. Adam, I appreciate your time with us. Thank you so much. But what do bold and systemic reforms in our corruption fight look like?
Well, maybe I should start out by saying that I'm a member of the board, and so we are working with government. We spent the entire week reviewing Ghana's anti-corruption architecture, and today's conference was a climax of that. So it's the African Union Advisory Board Against Corruption with the government of Ghana, reviewing Ghana. And I am proud of Ghana to have accepted to undergo this review. In terms of the various issues that came up, very substantive recommendations highlighting where we find ourselves. The fact that we've retrogressed on some of the most important corruption indexes, the fact that at the moment our legal regime looks at political parties, whereas when we look at the funding of political parties, it is the members of the parties engaging in campaigns who seem to have the money. And so the current regime is not fit for purpose because the parties will submit the annual report with not much money there. But we find that the presidential and other candidates must raise a lot of money, which is unaccounted for. The sources, whether legitimate or otherwise, are not known. There are issues of sanctions that must be tightened and made more clear for public officers who engage in various forms of breaches of the law or of anti-corruption, and many other similar issues and some constitutional changes we may need to make in order to make this fight much more progressive. So it's a very useful gathering and apex point for the week.
And I take it as that, gathering is the beginning of the implementation of some of these systemic and bold reforms?
Absolutely. So we started the week engaging what we call the National Anti-Corruption Agency, which is TRAJ. We spent the second day with the presidency. We went on to the Attorney General. We met the Speaker. We met the judiciary. All the key stakeholders that must play a role, ending with civil society over the last 48 hours. We will be submitting recommendations to the government of Ghana by the end of July, at least a draft report for the country to look at and come back to us. We are hoping that that too could feed into the constitutional review and other key decisions being taken. And hopefully some of the loose areas where, for example, we don't have clear laws on lifestyle audits, and we think that if you look at our convention, the articles highlight, at Article 14, highlight the need for an illicit enrichment lifestyle audit. These are things that must be put in place to make it much more difficult and risky for individuals to engage in corruption. And so we are hoping that once we submit, it will also add to the gamut of things that this government would like to do to ensure that we consolidate our fight against corruption.
The special prosecutor at this event talks about asset declaration, where he agrees with the flock that it's an important step in stemming graft. However, he does not believe that whatever is declared is published. Will that be part of those recommendations you forward to the president?
No, definitely not. Mr. Kennedy Agyapong, whilst we very much salute the effort he's been putting into holding current officers accountable. And we don't have many institutions that are doing enough of that. We think that the issue of publication is a non-negotiable. For all of us in civil society, this is best practice. We are not just saying verify the assets, but publish them. I guess that any public officer will be uncomfortable. But if you seek public office or accept public office, you should accept the fact that public people will scrutinize you, will put a more microscope to what you're doing, and now whatever actions you take there are things that the public has every right to interrogate. So both verification and publication, just like sister nations are doing in Nigeria and elsewhere, is a non-negotiable, and we expect that will also be part of the recommendations.
Another problem highlighted by the Vice President is political party financing. Is one many of you anti-corruption campaigners have also spoken about a lot in times past. What are the recommendations being forwarded to the President on that?
Well, so I mentioned one, but let me just start out by saying one of the things we've said is that the political campaign season must be defined. And we think that we do not need much more than a 6-month period for political campaign. It's because by the time we end the second year, get into the third year, people start campaigning. So you have 2 years and we are talking in billions in terms of what is being used at the moment. Absolutely unsustainable. It means that individuals are getting into government indebted, and when they get into government, they must find ways and means to pay back. So a shorter political campaign season legislated, which means that when you breach it, it is punishable. It's one of those things, not more than 6 months. From July to November, or is it June to November, December should be fine. That's one of the very concrete suggestions that have come up. The other thing is that we are clear in our minds that the political parties themselves are not the ones receiving the bulk of the money. It is the individuals who are campaigning either for parliamentary, presidential, or other positions. And so we need to reform our law. Some legal reform is necessary to make the current law, political parties law, which the Electoral Commissioner is responsible for, much more effective at looking at individuals, what monies are coming in, how they is being utilized, and ensuring that we don't get the proceeds of crime, funding these persons. And before you know it, we have state capture or personal capture that then takes over our government. So these are some of the concrete suggestions that have come up so far.
Beyond forwarding those recommendations to the government, what are your expectations?
Well, there has been, in our engagement with the president on Tuesday afternoon, he said, and this is to paraphrase, that, look, he's clear that he's not coming back for election. He wants to leave a legacy, and some of that time has gone. In fact, the National Advisor on Anti-Corruption says, listen, our president has 3.5 years left. We better just put together what we need to do to make Ghana much more secure. It appears to us that this president is taking this fight seriously and wants to have an architecture that allows us to do much better. We hope that that political will translate into execution of the recommendations that we provide over the next 2 months, and that we'll be able to take it forward in building a stronger, effective campaign against corruption in this country. We've also talked about how the base of all of this is the issue of integrity, the values of our society. So one of the things that came up over and over again is the need for public education, starting from kindergarten through primary. What are the core values that we stand for? What are the models of integrity and honesty and hard work that we are projecting, ensuring that the next generation can stand for it? Our greatest asset is our young people. It's also our greatest hope. And we need to make sure that we, as it were, nurture them to be champions of anti-corruption for the future.
Adam, thank you so much for your time and insight on the subject matter.
And thank you.
Adam Senano is co-chair of Citizens Movement Against Corruption. He's also a member of the board reviewing Ghana's anti-corruption architecture.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.